Good afternoon. My name is Laura Bacchus, and I'm the director of Dykema's Automotive Industry Group. Welcome to our second installment of our Dykema Automotive Trends webinar series. For today's installment, we're going to be focused on legal issues in the automotive industry related to labor and employment. A quick sidebar, there is CLE credit available today, so make sure if you're signed up, CLE forms will be provided after the program. And if you have any questions, this is Zoom format. You can type your questions there. We do have a full program, so if we don't have an opportunity to address questions during the program, please feel free to email the three email addresses referenced on the slide. Again, for CLE credit, please be sure to submit the record of attendance to the Learning Source email address, and you'll get the form after the program. Before I get into introductions, I want to remind everyone about Dykema's 2024 Automotive Trends Report, which this webinar series is based upon. Every year, annually, Dykema surveys the top in-house contacts, executives, and others in the automotive industry to find out what they're worried about, what they see as a hot legal topic for the year to come. And this is all summarized in our Automotive Trends Report with key legal analysis for some of our top attorneys in a variety of areas in the automotive industry. So if you click that QR code, you're able to get a copy, or feel free to email one of the presenters today, and they'll be happy to send you a copy of the report. For today's series, you have Jim Herman. Jim is out of our Detroit, Michigan office, and he's the leader of our Dykema's Litigation, Employment, and Labor Group. Jim focuses on all things employment law, from counseling to litigation, with non-competes, trademarks, RIFs, harassment, and everything in between. In the middle there, we have Shar Carney. Shar is based in our Los Angeles, California office, as well as our Ann Arbor, Michigan office. Shar does a webinar series for Dykema called Shar's Corner, which focuses solely on California employment issues, which are, ever changing and always something that you need additional information on. So please watch LinkedIn and go to Dykema's webpage for the Automotive Industry Group or the Employment Group, and you can click on registration for Shar's Corner if you have interest in California employment law specifically. And then we have Abad Lopez. Abad's based out of our Chicago office, also national practice like Jim in Charlotte. He's the assistant practice group leader for Dykema's Labor Employment Group. Like Jim, Abad practices litigation as well as counseling for all sizes of clients and employment-focused matters, from harassment to RIFs to trademarks to everything in between. So with that said, I invite Jim to take the floor and start the series. Thank you.
Thank you, Laura. So in the course of conducting the survey, we really identified three major issues that a lot of the participants were identifying as being concerned to them. One is the lingering effects of the UAW strike that we all experienced in the third and fourth quarter of last year. The second being the impact of artificial intelligence on labor and employment, and the third being the future course of non-compete agreements and where those are going. So I'm going to address that first topic and then hand it over to Shar to talk about some artificial intelligence topics, and then Abad will close dealing with non-competes. There were a whole lot of other issues you identified, but we had to cut it somewhere, and so we took the top three, and that's where we ended up. So let's start with the lingering effects of the UAW strike. So just to set the table on where we began. So if you'll all recall, around this time last year, we were dealing with a new UAW president, Shawn Fain, who had announced that workers are fed up with the status quo and was making a lot of very loud public promises about the massive improvements in economic and non-economic conditions they were going to see as a result of the collective bargaining process that was taking place later in the year. In the months leading up to that strike vote, there were promises being made from an immediate 20% wage increase, that he was going to get for the workers, that there were going to be annual increases to follow, resulting in a total wage increase of 46% over the life of the contract. He made promises they were going to strike until they got a restoration of a traditional defined benefit pension plan, which is just doesn't exist anymore. It was also saying they were going to continue in their strike until we had a restoration of the retiree health care benefits that the big three had finally been able to shed, and that there were non-economic terms like they were going to have a 4-day work week instead of a 5-day work week, job protections, and involvement in the transition to battery and electric vehicles. Unsurprisingly, that sort of line in the sand negotiating didn't go real well, resulting in a strike against all three of the Detroit automakers beginning on September 14th, 2023. The strike was a little bit atypical. Historically, there's been a strike target that's been selected by the UAW, which then results in a collective bargaining agreement, and that becomes the focus of pattern bargaining going forward. But instead of going down that line last year, what happened is the UAW said, we're going to strike all three of the Detroit three at the same time, but we're not going to walk out of all the plants. They targeted the strike to particular different facilities, saying we're going to strike a distribution facility or a parts distribution facility, which is going to have impacts that ripple up the supply chain, so that the fact that there's a strike at a distribution facility means that there are 3 assembly plants that are going to be affected because the parts from that distribution facility aren't getting there. And then they continued to escalate and change the different locations that were being struck at any given time, so that when the negotiations were going well, they would give a reward to the automaker that was doing what they wanted them to do by, we're not going to increase the scope of the strike, or we're going to pull back on what we're doing. Or if they were displeased with a particular proposal, they would increase the pressure by saying we're going to strike a more economically important plant. And ultimately, what ended up happening is when they started to get to some of the very high margin truck plants, a resolution was resolved or came up with where there was a collective bargaining agreement that was agreed to. So the strike lasts until late October, with Ford reaching a tentative agreement first, then Stellantis ending with General Motors on October 30th. They all are ultimately ratified by majority vote of the membership. General Motors was a little bit dicey because there were some terms that some of the members took issue with, given the promises that President Fain had made to them. But all are ultimately ratified. And in general, this was a real big win for the UAW. There were a lot of benefits that its members got out of these collective bargaining negotiations. Obviously, each collective bargaining agreement varies a little bit, but in general, what happens are wages are increased substantially. There's an 11% wage increase immediately at ratification. The top wage ends at the end of the collective bargaining agreement for the people with the most seniority at $40 per hour at the end of the term, or $83,000 a year if they don't even work any overtime. So that's a major wage increase, 25% increase in their compensation out the gate without any overtime being taken into account. They also negotiated a faster progression to that top pay rate, that you get to that $40 an hour or over $40 an hour number quicker. Enhanced retirement benefits, although the Detroit Three were able to fend off that pension plan demand that President Fain had raised. A real increase in pay for the temporary workers from $16.67 an hour to over $40 an hour at the end of the contract, and speeding their conversion out of that temporary worker status. They maintain the right to strike over plant closures, so they have voice in product planning going forward. And importantly, to the UAW, the inclusion of many of the new battery plants and BEV plants that are being set up that were included in the master agreement. So, this was uniformly seen as an enormous win for the UAW. They got a lot of things that really advanced their position for their employees and really moved the needle, showing the value of the union. So what are the reactions to that? Well, first, the White House showed unprecedented support throughout this process. It's hard not to recall that during the strike, we actually had a sitting president of the United States joining the picket line for the UAW workers, picketing one of the Detroit Three. Absolutely an unprecedented, support of the labor movement that occurred during that strike. And we have Joe Biden continuing to say that he's the most pro-labor president in the history of the United States. A cynic might say that there's a question if he's pro-labor because he's concerned about the benefits versus concerned about the votes in the upcoming election. But regardless of the reason, that's what he keeps saying, and that's what he keeps doing. Even in the aftermath of the deal being struck, there was a great deal of rhetoric coming out of the White House about what how this strike campaign and the ultimate collective bargaining agreements that were arrived at showed the value of the union process, showed the value of unions in the workplace. and really was a feather in the cap of the organized labor movement and the UAW in particular. The UAW not needing a lot of encouragement really starts to focus on using this as a jumping off point to grow their membership. Membership at the UAW is historically low. To take it in perspective, back in 1970, the UAW's membership was 1.5 million. That dropped to a historic low of 355,000 in 2009, in the middle of the Great Recession. There was a minor rebound in 2020, but they're still back down to 370,000 members as of the filings they did last March. So that is a very low number of members. That's a low number of people that are paying dues every month. That impacts the ability of the union to influence policy through the political process and lobbyists. It impacts their ability to go out and organize new factories. So they really see there's a need to increase their membership to maintain their influence and their financial viability. And as part of that, they've recently announced a $40 million campaign to organize new facilities over the next 2 years. And they've made it clear their real focus is going to be on non-organized labor assembly plants. So read that as the assembly plants with a lot of the foreign manufacturers that are in the South, as well as electrification plants. So new battery plants or places that are making battery electric vehicles. Those campaigns have already begun. Volkswagen in Tennessee has an election that's going to happen a week from now, starting on April 17th. Remember, that's a plant in Chattanooga that has twice rejected the UAW attempts to organize there. That is going to start happening in the election on the 17th through the 19th, and we'll see where it goes. But given the strides that were made by the UAW in this last round of negotiations, the betting money at this point is that plant's likely to become a UAW plant. Likewise, Mercedes-Benz in Alabama, a petition for election was filed last Friday down in Alabama, and that'll be an election that happens by the end of the month there as well. Others are obviously in the crosshairs. The UAW has been very clear in its public pronouncements that they're going after Nissan, Tesla, Toyota, Honda, Hyundai, all locations that they're trying to make sure that they're getting their foot in the door in, because they view those people as the UAW members of the future. In the past, those plants were sort of seen as competitors, an alternate way of organizing an assembly plant. This UAW president takes the view of that might be an alternate way, but we have a better way, and these are our members of the future. So we're not going to disparage them. We're going to bring them into the fold, and then we're going to make them UAW members. So that is the ultimate goal, and they've got a lot of ammunition out of that because of the great collective bargaining agreements they were able to negotiate coming out of the strike at the end of the year. They're getting a lot of help from the National Labor Relations Board. There were some major changes that have happened in the last year at the board, spearheaded by changes to the NLRB's election rules that were effective on December 23rd of 2023. So this is really a return to the quickie election rules that were promulgated during the Obama administration. During the Trump administration in 2019, they rolled back and said, we're going to do it the old way, where you have to have a longer period of an election. Once a demand for an election occurs, you're going to have longer periods to have hearings. We're going to resolve a lot of issues out of the gate. All that was wiped away through these new rules that came into effect on December 23rd. We're going to have quick pre-election hearings, so 8 days from the time you get a notice of a hearing to a hearing actually occurring. Quick distribution of petition notices, no more than 20 days from the time that a notice of an election is given and the actual election occurring. Very limited adjournments. So they basically, for extensions for hearings, the general counsel has taken the position that will give 2 days time for quote unquote special circumstances and more than 2 days only for quote unquote exceptional circumstances, without defining what those are. But in this general counsel memo 2402, they go through these rules, and the general counsel of the NLRB says, look, we're putting these rules in place specifically because we want to accelerate this election process. Employers shouldn't be getting notice of a union likely representing a number of its employees, and then be able to stall through this election process for many months while they're taking advantage of the system. Instead of that, we're going to go to the election quickly, we're going to get a resolution, and we're going to move forward from there with bargaining. So there's been a lot of push from the National Labor Relations Board to increase the tempo from the elections. Now, they got some help through the Cemex construction materials case. This was a decision of the board that came out last August, in August of 2023, that really upends and rewrites the election and recognition rules for unions. So before Cemex happened, the typical process would be a union could come in with showing they had at least 30% support through a presentation of cards. At that point, they could demand an election. There would be an election process that occurs, and ultimately a majority vote would be required in order for a union to be recognized. Cemex turns that on its head. It says if a union comes to an employer and represents that it has 50% of the employees who've demanded a union, so they've signed a card. At that point, the company has to make a decision. They have three options. They can just voluntarily recognize at that point. And by the way, they don't have a right to say, well, show me the cards. It's a matter of if they say they have it, you have to either voluntarily recognize. They can file a petition for election with the NLRB, an RM petition, so management demanding a petition for election, or they can, quote unquote, act at their own peril and ignore or refuse the recognition request. But if that happens, ultimately they can be facing unfair labor practice charges, and there could be bargaining orders that resulted from that. So, instead of in the past, what we had in the past, which was we're going to have an election and we'll figure out whether we actually represent 50% of the folks that are here. It becomes the union says they've got 50%, and it's on to it's the employer's responsibility to promptly, within 2 weeks, make a demand for an election, which is then going to happen probably within 20 to 25 days of that demand being made. So it really accelerates the tempo for you having to get that election process completed. The other part of Cemex's problem is if you take option 2 or option 3, filing the petition for election or acting at your own peril, basically anything other than just sucking it up and saying, okay, we'll bargain with these people who purport to represent our employees. And there's an unfair labor practice that occurs in the course of the election. They can just issue a bargaining order. Now, there used to be a process called Gissel bargaining orders that happened where you had such egregious unfair labor practices that were occurring in the course of the election that it basically meant that there was no remedy the board could put in place that means there's going to be a free and fair election going forward. And in those cases, which were extremely atypical, there would be an order issued by the board saying, okay, you have to bargain because you screwed up the election process so badly, employer, that's the right remedy. That is no longer the rule post-Cemex. In Cemex, it basically says, if there's any unfair labor practice that happens, the board has the right to just say, we're not going to go forward with the election and we're just going to require you to bargain with this union. So, given that ruling, what it really means is you can have a union come in, claim they have some, right to represent these employees, that they've got cards from 50%, never show those cards to anyone, get in an election process, have an unfair labor practice occur, and the union represents these folks, even though there's never been any vetted process to guarantee that they actually continue to represent 50% or more of the employees. So it's quite scary. And they go through this process more in this GC Memo 2401. If you work in this area, I certainly commend you to take a look at that. It's available on the board's website. This is actually made a little bit worse, though, because of some other actions that the board has taken in the meantime. For example, last August, right around the same time that they issued the Cemex decision, they issued the Stericycle decision, which basically rewrote what neutral policies an employer can have that are promulgated to its employees. Before Stericycle, we were under this Boeing test, which basically said if it's a facially neutral policy and it serves a legitimate purpose, as long as it doesn't, on balance, overstep the bounds of an employee's rights under the National Labor Relations Act, it's fine. Stericycle throws that out and says, look, if it's a facially neutral policy and that rule could be interpreted, could be interpreted to chill an employee's rights to collectively bargain, it's presumed to be illegal. And an employer can only rebut that presumption by proving the rule advances a legitimate and substantial business interest, in the opinion of the board, and is unable to advance that interest with a more narrowly tailored rule. Right. So all those employee handbooks that you put out there, all the rules that you have in the workplace that were okay, a year ago, are now problematic and can actually result in a finding, in the context of the Cemex decision, that you have an obligation to bargain with the union because promulgating the rule was enough to be an unfair labor practice. That rule existed in the context of the union election, and under Cemex, that's enough to trigger a bargaining. So very concerning, and really a lowering of the standards that were typically required in order to have an organized workplace. Another rule that was promulgated during this time was the walk-around rule from OSHA. This was effective on May 31st. So it's coming up soon, which basically allows OSHA to bring along a person that they deem to be a representative of the employees. If they deem that there's good cause for that employee to participate, or that representative to participate in the election. The problem is the determination of who a representative is and whether there's good cause is left in the hands of the OSHA inspector. And there's a lot of concern, given the leanings of the current administration, this will be used as an opportunity to get union organizers into facilities, under the pretext of they're here to help the OSHA inspection, but really what they're going to be doing is looking for things they could use to try to organize the workplace. So a lot of increased NLRB activity that is going to increase unionization in non-unionized plants right now. The other reaction we've seen is significant upward wage pressure. That really takes a couple different forms. First, we've seen significant spikes in wages across the board already. A lot of pressure in organized workplaces to match the terms the UAW has come up with in their negotiations. But even in non-organized plants, there's been a lot of wage creep that occurred. There was a Reuters article that came out in December of 23 that showed wage increases being announced or rolled out at Tesla increasing its wages by 10%, VW increases by 11%, Nissan by 10%, Hyundai increasing all workers by 25% by 2028, Honda increasing by 11%, and it goes on. I mean, that's not a coincidence. Those wage increases are happening because these companies want to be able to say to their employees, look, you don't need the UAW in here. We're giving you the wage increases so you're in a competitive wage position without having to pay union dues. So you don't need the representation. That's why that is occurring. You're going to see that significant increase in wage pressure continuing, not only in the auto sector, but across the economy. The other thing we're seeing is compensation increases that are supported by governmental action. We certainly haven't seen an increase in the federal minimum wage in a very long time. It's still stuck at $7.25 an hour. But state and local minimum wage increases are happening. 30 states plus the District of Columbia have minimum wages that are above the $7.25 federal minimum wage. If you're watching the news in the last week, you saw the announcement about the $20 minimum wage for certain workers in California. You saw the $16 minimum wage in California. Those minimum wages have increased through governmental action, even if it's not on the federal level. And we've also got a set of proposed FLSA rule amendments to increase the white collar exemption compensation levels. So these were proposed last year. The comment period ended in November, and we're actually waiting for these to be issued as a final rule any day. Supposedly it said April 24. I checked the DOL website before we started this, and they haven't been announced today. Maybe tomorrow. But it basically means the minimum salary increase for your white collar exemptions is going to increase to $1,059 per week or $55,068 a year. There's a big increase for highly compensated employee exemptions as well. And minimum salary levels would continue to increase by an index every 3 years. There weren't any changes to the duties test, but you're going to see continued upward wage pressure as a result of this. That if your lowest level, assistant manager that you were paying $36,000 a year in salary now has to make $55,000, and now you got to bump the salary of your manager who is making, $45,000 up to $65,000 to keep them, online. So we're going to see, continued increased wage pressure from the white collar exemption to these new FLSA rules as well. I anticipate there's going to be litigation over this, just like we saw during the fair pay regulations during the Obama administration, and Lord knows how that'll come out in the end. But certainly this is on the horizon and something that employers need to be aware of. For other stuff that they're going to need to be aware of, I'll turn it over to Shar, who's going to talk about the developments in the artificial intelligence field.
All right, good afternoon, everyone. I want to talk about the use of AI in labor and employment issues. I have kind of an ambitious agenda for the next 20 minutes. I'm going to go over a broad definition of AI that was promulgated by Congress, then dive into examples of how Dykema's clients are already using AI in labor and employment. Most importantly, I'll discuss how use of AI will be regulated under Title VII, the ADA, and the National Labor Relations Act. And then last, I'll end with litigation implications, policy recommendations, and practical takeaways. So let's get started. The congressional definition of AI is really, really broad, as you can see. They defined it as a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. this encompasses a lot of things that you are already using in your workforce. Employers are already using AI to write job descriptions, track productivity, interview candidates, and make decisions on promotions and terminations. From what we've seen here at Dykema, we've got clients using resume scanners that prioritize applications using certain keywords. Employers are using employee monitoring software that rates employees on the basis of their keystrokes or other factors. They're using virtual assistants or chatbots that ask job candidates about their qualifications, video interviewing software, and testing software that provides job fit scores. So that's how it's being used. We're going to move on to what we're all here for today, is how the government is going to regulate AI. The federal government, including the EEOC and the NLRB, have indicated that they will use current laws to regulate AI. There's no movement federally to draft new laws to regulate AI in the employment context. Some states and cities are starting to implement new laws to regulate AI, though. For example, New York City now requires employers using AI to independently audit their systems for bias. Under that ordinance, employers are required to take an inventory of the hiring and recruitment software they use to evaluate candidates and audit it to see if it qualifies as an automated employment decision tool. And there are other states that are starting to propose similar bills. Legislatures in 31 states, the last time I checked, have introduced 191 bills focused on AI broadly. For now, however, we're really looking at current laws and what the EEOC and the NLRB have been telling employers through technical assistance documents is that the three main laws they will use to regulate AI right now are Title VII, the ADA, and the National Labor Relations Act. So I'm going to look at each of these really briefly this afternoon. The EEOC has said that Title VII applies to AI when it is used to make decisions about whether to hire, promote, terminate, or take other employment actions when it adversely impacts individuals on the basis of a protected characteristic or when it results in bias. One thing that Commissioner Keith Sunderling of the EEOC has made very, very clear is that employers will be responsible for the AI they use, even if it's from a third-party vendor. So it's going to be really important for you to screen your vendors, and I'm going to talk about that briefly in just a second. In addition, with regard to the bias component, the EEOC has indicated that it will monitor its complaints and look for complaints that indicate an imbalance based on selection rates. So the takeaway here is that you just need to be aware of any tool you use to make employment decisions and how those tools are ultimately impacting protected classes. In addition, if you have federal contracts, the Office of Federal Contract and Compliance Programs just updated its mandates to require federal contractors to provide information on recruitment and hiring practices and systems using AI. And this is all not just theory. The EEOC did just settle its first AI-based discrimination case against an organization called iTutor Group for a significant amount of money. So in those allegations, the EEOC alleged that the company's AI discriminated against older applicants. So there are ways you can run afoul of Title VII using AI that you need to be aware of. Now moving on to the ADA. The most common ways that an employer's use of AI decision-making tools will violate the Americans with Disabilities Act are with regard to reasonable accommodations, screening, and disability related inquiries. I'm going to take each one of those one at a time to kind of go into more detail. So let's look at reasonable accommodations. An example of a reasonable accommodation that could run afoul of the ADA is a job applicant who has limited manual dexterity and is required to use a keyboard to apply for a position. If you're using just AI to screen the applicant could be rejected without consideration of a reasonable accommodation. If you're using a human resource professional, like we have in the past, the human resource professional, as you all know, would engage in the interactive process, and the applicant could be accommodated with a reasonable accommodation, which in this case could be voice to text software. So that's a simple example of how you could run afoul of the ADA with AI. And what we have seen is going to be the best practice overall throughout, applying all these different mandates and laws is that you should use AI to promote your efficiency, but you should always have a HR professional overseeing it. Another example is screening. The best example here is a chatbot designed to engage in communications online. If you're using just AI, the applicant could be screened out due to gaps in his or her employment history. If you're using a human resource professional, the applicant could explain the reasons for the gaps in his or her employment history, which could be pregnancy or disability related, and need to be accommodated and not used as a screening tool. So the biggest worry here for your attorneys is that there are many vendors that advertise that their AI for screening applicants is bias-free. So far, I have not seen, and I don't think anyone has seen any AI that is completely bias-free. This is because AI is only as good as the data that we give it. The third way that you could run afoul of the ADA is with regard to disability-related inquiries. And this example, although it is kind of funny, comes directly from Commissioner Keith Sunderling from a seminar I went to that he was presenting at. An example he used is a test that screens for optimism. He said that AI may screen out an individual with major depressive disorder, which could violate the ADA if the individual could perform the essential functions of the job with or without a reasonable accommodation. Obviously, if you're using your human resource professional, the professional could determine whether optimism is truly an essential function of the position and accommodate the person if it is not truly an essential function of the position. So as you're probably guessing through my presentations thus far, the best practice is using AI, again, to increase efficiencies, but also having a human review your use of AI. I'm not going to define Section 7 for you because Jim just went over a whole presentation on Section 7 rights. Suffice it to say that last year, the General Counsel of the NLRB issued a memorandum, and it was really quite stunning. It said that it is not advocating for new laws to regulate AI, but is urging the board to interpret existing board law to adopt a new legal framework to find AI illegal if it interferes with protected activities under Section 7. And what is stunning here is they didn't say there was a reasonableness test or anything like that. It just said to adopt a new legal framework to find AI illegal. And the General Counsel told its board members to scrutinize technology tools that rely on data collection and surveillance of workers, which is really broad. And the examples they included are listed in this slide, but suffice it to say that many of our clients use these devices and have for years and have not considered them AI. Interestingly, Jim and I both went to a state bar function where the local NLRB representatives were in attendance, and we were asking questions about this memorandum, and they were just as perplexed as we were about how this would be enforced. So stay tuned. Maybe next year's Dykema Drives update will have some details. Now that I've probably scared everyone away from using AI, I do want to point out that there has been some really, really good uses of AI in human resources functions. Many of our clients have used it to draft job descriptions. AI is also really, really accomplished at focusing on skills-based hiring by ignoring factors that humans unconsciously take into account in interviews, such as attractiveness, background, social skills. It essentially gets rid of our own unconscious biases, which is a great thing. Also, as many of us know, women by and large underreport their skills, and the data shows that AI is reducing that underreporting, which is great. You can program the AI to disregard for protected characteristics, especially names, which are often indicative of protected classes, sex, religion, national origin, and race. You can also program AI to disregard foreign accents or speech impairments. And in an example given by Keith Sunderland, again, AI can keep employers from doing things that have been found to violate Title VII in the past, such as denying a position to a woman because she is visibly pregnant. Obviously, the AI in most instances cannot tell if the woman is visibly pregnant. There are still some bad consequences. The biggest thing we have seen so far is that a lot of the AI will disregard speakers who are not fluent English speakers, which is obviously national origin discrimination. The biggest thing to remember again is AI, whether it comes from a vendor or from internal software, is only as good as the data that it is based on. For example, if the data you input into AI indicates that 80% of your engineers in your workplace are men, then the AI is going to create an algorithm that weights sex in favor of men over women. And remember, the EEOC doesn't look at intention, it looks at impact. So I want to briefly touch upon litigation implications for using AI. The biggest one that I've already seen is that employers should be aware that the EEOC's current strategic enforcement plan includes a section telling all of its investigators to take a good look at EEOC complaints and to see if they are based on AI. And it says that they're going to be, I guess, rated based on those metrics. So the EEOC investigators are going to be rated on the metrics of locating due process complaints that implicate AI biases. So that's something you need to watch for in your due process complaints. In addition, AI creates discovery. It creates evidence that would not otherwise be available regarding decisions regarding terminations and hiring. In a lot of instances, this is good evidence, and a lot of instances, it can be bad evidence. So you just need to be aware that we are creating more evidence with the use of AI. That leads us to policy recommendations and practical takeaways. First, if you don't get anything out of this 20 minutes of mine today, the takeaway should be that you have to screen your vendors. If you are using AI from an outside vendor, or software from an outside vendor, I should say, even if they advertise that they are bias-free, ask about litigation they've been involved in and complaints regarding discrimination. Second, make sure you ask your vendors, if you're using vendors, to forward all requests for accommodations to someone internal to your organization. Do not have the vendor handle the accommodation request. Third, inform all applicants and employees that are being rated by AI that reasonable accommodations are available. Fourth, if you're creating your AI internally, creating your own software, which I do have clients doing, make sure you use good data. Do not use data that implicates stereotypical biases in our culture. Fifth, audit your use of AI. I would recommend reviewing your use after a year or so to determine if, on your own, if your data is producing a workforce that is biased against a protected characteristic. Last, create a policy that contains a notice of your use of AI, a restatement of your EEO policy, and a complaint mechanism similar to the complaint mechanism you have in your sexual harassment complaint. And then make sure there are clear instructions regarding requests for accommodations. Train your employees on AI, including them having them attend even a brief seminar like this 20-minute seminar, just so that they are aware of how it could violate current laws. The more knowledge you have about AI, the better. In closing, I just want to say that employment bias is out there and AI is not changing that. The EEOC has collected millions of dollars a year from when I started practicing through now based on bias, and AI hasn't increased or decreased that. But you should make sure that if you are using AI, that you are not afraid to discontinue its use if you see that it is resulting in bias. Put significant time into your research with regard to AI, and don't be so quick to jump on the new best software. I think that's it for now. I will take questions via email most likely after, and I'll turn it over to Bob.
Thanks, Shar. Okay, so I'm going to talk about the non-competition, non-compete landscape going into 2024. There's a lot of activity both at the federal and state level. So I'm just going to briefly touch on what I hope to cover in the next 20 minutes or less. So I'm going to talk about what's going on at the federal level, which includes at the FTC and NLRB. The proposed bans on non-competes, in addition to some enforcement action at the federal level that has not had much success so far, but nonetheless shows the enforcement efforts from the top. And then I'm also going to talk about what's going on at the state level, and each individual state, which I'll touch on as I go through the presentation, has its own unique approach in some respects, but I'll touch on what I see as trends and also talk about California's approach, recent development, and how it's tackling non-compete laws and some other states. And then I'll leave you with some suggestions and takeaways on best practices for non-competes, which is something that is prevalent and why you see so much activity at the federal and state level. So I'll start with talking about what the Federal Trade Commission has done. And in January of last year, the FTC published a proposed rule which effectively banned all non-compete agreements, and in some sense was interpreted to have a de facto approach, which could have been interpreted to ban any non-solicitation, non-disclosure agreements. Now, it's still going through the rulemaking process. There expects that there'll be a rule will be issued in the spring of 2024, so really at any time now. And as proposed, the effective date would be 60 days after the final rules publish. And after that, the compliance date will likely be 180 days after the final rules publish. Now, just to get a sense of what the FTC's proposed ban on non-competes means for all employers. It would be, it's a broad rule, a broad ban would apply, but what does it actually mean? Well, the FTC can bring civil enforcement actions, it could seek penalties, it could seek injunctions, but there's no private right of action, which I know is important to many employers, does exist in some other contexts, but does not exist for this rule. But the most significant impact, I think, will be in potentially actions to seek that are essentially meant to void the enforcement of restricted covenants or really have existing non-compete agreements declared unenforceable once this rule actually goes into effect. I mean, there expect to be a lot of court challenges to this rule before it actually goes into effect, but nonetheless, that is the intended effect of this broad application. So it does create that argument for employees to, if this rule is in effect, to essentially say, well, look, this is not an enforceable agreement, so it's per se unenforceable. I don't have to abide by this non-compete. And it also just creates a leverage to create for employees to report this potentially unlawful conduct to the FTC, and will create a headache for employers. So that, again, is something that is winding its way through the system. Expect some additional news shortly on that rule. But it does have fairly broad implications. So as I said, the summary of the rule would bar most non-competes. It essentially bars any attempt or actually any existing non-compete or attempt to enter into a non-compete, the maintenance of any non-compete agreement, and then representing to any worker that there's a non-compete in place. Many employers, even if they don't intend to enforce the non-competes, the fact that there's one in place is viewed as having a deterrent effect on potentially competitive, unlawfully competitive or unfair competitive activities. But that would be unlawful under this proposed rule. So it's very broad, and it also applies to independent contractors and unpaid workers. And so again, the extent of this also extends to any de facto non-compete clauses. So any contractual clauses that may have the effect of prohibiting workers from seeking or accepting other employment. This means that it could potentially extend to non-disclosure agreements, which are also very common in the employment context. If they have the effect of limiting an employer's mobility, just by way of a pretty straightforward example, if the confidentiality, non-disclosure provisions are so broad that the employer would be unable to work within the same job category in the same industry without violating that would potentially be a violation of this new proposed rule. There is also a ban on the requirement that there's the repayment of training costs, which has also become popular in recent years as potentially restricting agreements that are seen as onerous and not really tied to the cost of training an employee. If an agreement seeks to recoup those costs and it's not tied to the actual cost of the training, then that could be seen as a de facto non-compete provision and thus barred under this new rule. There is a limited carve out for the sale of a business. If an owner owns the sale of a business for a non-compete clause, and so that is defined under the rule as a 25% or more owner of the business. So in addition to the FTC, there's also been a lot of activity in Congress. So I just listed a couple of recent bills that were bipartisan bills, both at the House and at the Senate. The latest in February of 2023 in the Senate, and there was one in February of 2023. They're still in committee, they're winding its way through, but it shows that there's pretty widespread support, at least at the federal level, for passing some kind of legislation that would limit these types of non-compete. So These bills are very similar, and they basically do exactly what it sounds like. I mean, they would essentially bar any non-competes with limited carve-outs. So any existing non-competes would have no force in effect. There's an exception within these proposed bills for the sale of a business, some C-suite severance agreements, and also in the context of the sale of a business. Now, for these, it's important, these proposed bills, which we'll be watching closely, there is a private right of action and with a provision for fee shifting, so the recovery of attorney's fees for under these actions. So that creates a huge potential additional leverage for an employee seeking to invalidate existing non-compete agreements. So there's also additional carve-out for trade secret protections. And again, we'll be closely watching these developments because given that this would be at the federal level, it would potentially apply across the board and supersede any existing state laws that are maybe to the contrary. So I want to talk briefly. I know we've talked about the NLRB's action on this, but there was a memo in May of 2023 that was the NLRB's general counsel issued a memo. Essentially, which was well publicized, and it essentially stated that most non-compete agreements are per se unlawful because they violate Section 8 of the NLRA and also Section 7 because it interferes with the employee's ability to be mobile, to leave work, to bargain collectively and engage in other concerted activities because of the effect of these non-compete agreements. So it essentially sought to invalidate nearly all post-employment non-compete agreements, even those that would otherwise be clearly valid under state law. So again, her rationale was that any agreements of this nature would limit future employment and interferes with an employee's Section 7 rights. So it was very ambitious. It was striking. It really described as having an unprecedented scope in its attack on these types of agreements. So again, just to reiterate that the rationale was that the overbreadth of these non-compete agreements, I mean, that these were aimed at just attacking any non-competes that could somehow impede the ability of an employer to change jobs, cut off access to employment opportunities, talk to other employees in the context of confidentiality agreement about terms and conditions of employment. And the reasoning was that it would chill the protected activity. And as a natural outgrowth of this memorandum, there was a recent complaint, in the fall of 2023 by the regional director of Region 9 of the NLRB, filed a consolidated complaint to set out the view that a company's conduct, the proper maintenance and enforcement of restrictive covenants violated Section 8A1 of the NLRA. So this particular employer it was pretty ripe target for this type of complaint. Reading the complaint itself, the employer included very broad language in its offers of employment, employee handbook, non-compete and confidentiality agreement, and its exit agreement. So the non-compete agreement itself, essentially, and you can see I summarized some of the provisions in these agreements that were at issue in the complaint, and which survived a recent motion to dismiss in December. So we'll be moving forward. It essentially prevented employees from practicing aesthetic medicine for 2 years within 20 miles of any location after the termination of employment, regardless of the reason. Also threatened the former employees to repay their training costs if they ever violated the non-compete provision. So this is just an example of the NLRB's efforts to really put its money where its mouth is in terms of the very clear message it sent with its by its general counsel that it considers any of these provisions, and it really picked a good one, I think, here to pursue that are overbroad. So it's something to really pay attention to and to take a close look at. Department of Justice also was pretty active in seeking to invalidate no poach agreements, and in this case, these cases it actually sought to its antitrust division sought criminal liability for no poach agreements of employees, so agreements between companies to not solicit or steal, either hire one another's employees, also agreements that would essentially discuss or limit wages, suppress wages, so agreements that would effectively say, well, here's the wage rate we're paying, so we're all going to agree that this is the same rate we're going to pay within the industry. Well, in this context, the Department of Justice has not been successful. There were a couple of acquittals, and the Department of Justice dismissed the latest no poach complaint for an alleged no rehire agreement. So could signal a change of direction for the Department of Justice, but nonetheless, there are still some civil penalties based on earlier pronouncements on its view that these types of agreements are unlawful and potentially violate antitrust laws. So still signals maybe a shift, at least from the criminal standpoint, but I don't think its philosophy will ultimately change. So I want to talk a little bit about the proposed bans and non-competes, and state laws vary in this context. But California, which has long barred non-compete agreements, but it recently passed 2 new laws that make non-compete provisions even attacks them even further, in that it requires them to notify employers, current and former employees, going back to January 2022, that they are void. And it prohibits employers from attempting to enforce a contract that is void, regardless of whether the contract was signed and employment was maintained outside of California, which is an important shift, particularly for employees that may be remote. So I think that's an important development in that regard. I mean, of course, each state, in New York has a proposed ban that was passed but vetoed by the governor. But there's an expectation that there will be renewed activity in 2024. Now, of course, every state has its own framework for restrictive covenants. There's some prohibitions like California, North Dakota, Oklahoma, others within certain professions, and some have imposed certain criteria for enforceability, such as certain wage levels, like here in Illinois at 75,000. And sometimes the analysis will go into what legitimate interest is actually being protected, and enforceability considerations such as the employee's role, the territory that is sought to be limited, and the information sought to be protected. So some important takeaways as we wind down here to the top of the hour. So again, there's different frameworks that we're working with at the federal level and also at the state level. So we need to be cognizant of all of those regulations, those laws, especially as I talked about the bill that's winding its way through Congress. And so make sure you review, update restrictive covenant agreements, to know what you have. It's a surprise that sometimes people pull something out that they didn't know was something they've been using for 15 years and it's never been updated, but they just hand it out basically with every orientation packet. So implement updates to comply with the applicable law, of course. And then just make sure that they're tailored in order to ensure enforceability and not to run afoul of any existing laws. Make sure that there's really thought given to the employee's position, what information they will have access to, really what it is that how the agreement will be defended in court. Always think backwards. If this were in front of a judge, would they say this is way overly broad based on what this employee is doing, or would it be enforceable? And then just take a look at the state-specific nuances to just adapt. So top of the hour, got through the presentation, so I think we're done. I want to thank everyone for joining. Unless we have anything else to close out, I think we're good.
Thank you, everyone.